Hi, this is Ben Freer, and today I'm going to talk about E-2 visa partnership scenarios. Starting a business can be better and frankly much more fun when you have a partner along for the ride. Joining forces with a partner can allow you to have a bigger, more impactful business. And having a partner can help you get through all these stressful times that inevitably come when you're trying to start and grow a business. But how does a business partnership work in the E-2 context? The good news is you can absolutely use a partnership to qualify for the E-2 visa. However, there are some things that you should know about this option. So I'm going to go over two common E-2 visa partnership scenarios and talk about some of the requirements that can be difficult to meet when you have a partnership. The first common scenario involves starting a partnership where there is one US citizen and one foreign national that is a national of an E-2 treaty country. This type of scenario can be beneficial from a logistical standpoint. If the foreign national partner is abroad, the US citizen founder can start the business and begin operations. This is great because one of the requirements of the E-2 visa is that the business is either operational or right on the cusp of becoming operational. The second scenario involves two foreign nationals from the same country who are both interested in coming to the United States in E-2 visa status. While not as advantageous from a logistical standpoint, this is possible as well. While both of these scenarios are very much possible, there are two specific requirements of the E-2 visa that can be challenging in partnership situations. The first requirement to be aware of is that you, as the investor, must have the ability to direct and develop the US-based business. If the foreign national owns at least 50% of the business, then joint control is presumed. However, if the foreign national owns a lesser percentage of the business, say 20 or 25%, then proving the ability to control that business may not be possible. So as a general rule of thumb, in this type of scenario, where there's one US citizen partner and one foreign national partner, the foreign national partner should own at least 50% of the E-2 enterprise. The second requirement that can create problems for partnerships relates to the proportionality requirement. This requirement says that the investor's investment in the business must be proportional to the cost of establishing the business. So for example, if the business costs $70,000 to start, then $70,000 must be invested. But if there are two investors who each invest $35,000, then together they've invested enough to make the business work. But since neither person is actually investing enough by themselves to make the business operational, then they could face denials. So what can you do if you're in this position? There are a few possible solutions here. One option that works really well when there's one US partner is to have the US partner loan their share of the money to the foreign national partner. The foreign national partner can then invest 100% of the funds that are needed to start the business. Another option that works well when there's one US partner is to categorize the foreign national's contribution as startup expenses while categorizing the US partner's contributions as cash reserves for operating expenses. But of course, this will only work if the foreign national's contribution is large enough to pay for all the necessary items that are needed to make the business operational. Now, if there are two partners who are both foreign nationals, both from the same treaty country, then things get a little bit more tricky. Assuming that they both want to own 50% of the E-2 business, then one option is for the partners to pool their investment in a holding company. The holding company would then set up a subsidiary, which will be the E-2 visa business. The holding company would then invest in a subsidiary, which would be the E-2 enterprise. And once the investment is committed and the business is either operational or close to becoming operational, then the partners of the holding company could apply as managers or executives of the E-2 enterprise. So there you have it. There are a few of the common E-2 visa partnership scenarios. If you are interested in pursuing the E-2 visa based on a potential partnership, then I recommend that you reach out to one of the many amazing U.S. immigration lawyers that you can find across the globe. I hope this information was helpful. If you did enjoy this video, please like it or pass it along to someone who could benefit from it. Thank you for your time.